All right, let's get reaction to the story. We can speak to Ulrich Roux from Ulrich Roux and Associates. Ulrich, thanks for your time. We appreciate it. So another delay, this, of course, pending the finalization of Zuma's application to the SCA, of course, Judge President Mandisa Maya. He wants her to reconsider her court's refusal for his application regarding leave to appeal, that outcome in particular. Is this actually normal? Because according to Judge Kuhn, it is, and he does have the right to make this application.
Hi, good evening, Shahan. Thank you for having me. Yes, certainly Judge Kuhn was at pains to make it clear today in court that Jacob Zuma is entitled and he is full within his rights to exhaust his appeal options and the appeal process. And our Superior Courts Act does make provision for a further appeal to be launched towards the Judge President of the Supreme Court of Appeal, Supreme Justice Maya in this instance. He did approach the SCA on a petition saying that the SCA must make a ruling that Advocate Billy Downer should not be the prosecutor on the matter, that he is not objective and that he is biased towards Jacob Zuma. That was dismissed, and he is now exercising his right for the Judge President to take that on review. Of course, this matter has been delayed on so many occasions, so it does certainly seem as if this is just one further delaying tactic by Jacob Zuma. But strictly speaking, in terms of our Superior Courts Act, he is fully within his rights to explore this option of approaching the Judge President of the SCA, and he's obviously exercising that. And just briefly, in terms of our Criminal Procedure Act, a judge or presiding officer can postpone a matter if he finds that it is either necessary or expedient. Now, in this instance, he's saying that, well, if Judge Maya does make a decision that Billy Downer must be removed as the prosecutor of the matter, then that would obviously have a material effect on the outcome of the matter, and it would be in the interest of justice for there first to be clarity pertaining to that decision before the trial proceeds.
Yeah. Now, this is what I find interesting, because the Supreme Court of Appeal dismissed would cost the application for Zuma to have that right to leave to appeal. And it didn't say that it was on any reason but for. They say it was not only on the grounds that there was no reasonable prospect for success on appeal, but that there was no other compelling reason why an appeal should be heard. So we had that ruling, and now we have the Judge President Maya having to decide whether or not the judges of her court were right or wrong. That's ultimately what's happening here.
Yes, exactly. So just to make it clear, even though he has the option or the recourse to approach the Judge President, I don't think that that's going to be successful whatsoever. I don't think that there's any chance of success of him approaching the Judge President, but he is fully within his rights to do so. So we must now, unfortunately, go through this process, and the start of this trial has to be prolonged even more.
Question is why they didn't go back to the Supreme Court of Appeal before the first day of trial. What do you read into that?
Well, I mean, they did leave it late. To my knowledge, they have furnished the court with proof that they have addressed correspondence to the Judge President. So that has occurred. But yes, I mean, this is, once again, the judge needs to decide whether they have acted improperly or not. Should they have launched this review to the Judge President at a sooner occasion or not? And how does that affect the trial that needs to commence in court? He obviously weighed up all of those different factors, and he found that it is in the interest of justice, even though they approached Judge Maya, Chief Justice Maya, very late, that he is fully within his rights to do so. I think what's also important is that he has now also indicated through his foundation, the Jacob Zuma Foundation, that he is going to institute a private prosecution against Advocate Billy Downer. Now, that is in terms of Section 7 of the Criminal Procedure Act. Any entity or private person is entitled to institute a private prosecution when the NPA decides not to prosecute a person. So Jacob Zuma is saying that even though the NPA has decided that there's no reasonable foreseeability of a successful prosecution and they will not be prosecuting him, he is now going to exercise his rights to privately prosecute Advocate Billy Downer for wrongfully disclosing Jacob Zuma's medical reports, and for that to then end up in the media pertaining to his medical condition. Whether there's any chances of success in such an application, in my opinion, is very remote. But once again, he's entitled to do it, and he's within his legal rights to do so. But yes, one would have to consider whether all of these applications are in fact an abuse of the process in an attempt to further postpone the matter, or whether he truly feels that there's any merits of success. Once again, if he now approaches the Chief Justice Meyer of the Supreme Court of Appeal, and it is unsuccessful, he will once again have a cost order being made against him, and that is how the court would want to try and convince him not to pursue any further applications in this regard, and let's get this trial started. It was certified trial ready in 2018 already. So it's 4 years since the trial could have started, and it hasn't even started yet. And this is from a man who professed from the outset that he wanted his day in court. He wanted to prove his innocence, yet he's at every opportunity he's trying to delay the start of the trial. So it will be interesting to see what Chief Justice Meyer has to say about that.
Yeah, I guess that's what he maintains. We had his attorney saying the exact same thing today, but they want a fair trial. They don't just want to go to court if they have any suspicions around whether the trial will be fair or not. So talk to me about the private prosecution a bit more. You mentioned it at length, but what happens if there is a ruling in the private prosecution in favor of Jacob Zuma? Where does that leave the corruption trial?
Well, the private prosecution will be against Billy Downer, that he acted in contravention of the Criminal Procedure Act in having played a part in that confidential information being disclosed and being making its way out into the public. But that is a case of Jacob Zuma would have to appoint his own prosecutor, and they would prosecute Billy Downer in terms of the Criminal Procedure Act. The only difference is that he does so in his private capacity instead of the NPA doing so. So it is an interesting occurrence in terms of our law, because a private person makes use of the courthouse and the magistrates and all of the justice system's infrastructure in order to prosecute their own case. If Advocate Billy Downer is found to have acted in contravention of the Criminal Procedure Act, then I have no doubt that they will then once again launch an application for him to be removed as the prosecutor of the matter. If he is convicted, and a big if, that will not automatically mean that he is no longer the prosecutor on this matter. It will have to be an application which will have to be adjudicated upon on evidence that is adduced to the court. But having said that, the NPA is what we call dominus litis, and what that means is that they run a prosecution. They decide who the prosecutor is. They decide who the support team of the prosecutor is, and it is very seldomly seen that an application is successfully launched to have a prosecutor removed from a matter. Once again, in my opinion, there's absolutely zero chances of that succeeding. Our Criminal Procedure Act makes provision for it, that if a prosecutor is acting in an untoward manner or in an improper manner, then that should be raised during the trial, and that should be brought to the presiding officer's attention during the trial. To make claims prior to the trial commencing is always going to be a very long shot, and once again, I don't think that could be successful in any court.
Thank you so much for your time and the insight. Appreciate it. Legal expert Ulrich Roux.